Hi, everyone. Carl Steinbeck here. Just want to talk on this Monday night about the Sarah Boone case. I did say I was going to pivot over to some other cases to cover. And just before I do cover the Sarah Boone case and the first day of the jury selection here, what I did want to mention was on the back to the Adelson case in Florida, the Tallahassee, Florida case. That one is going to have Charlie Adelson's. His appellate brief is due this Friday, the 18th. So I plan on doing a live stream later Friday night, this coming Friday night, the 18th, covering what I have for an opinion on what has been filed by his defense counsel, his appellate defense counsel, Ufferman. And I do expect that to be primarily focused on, among a number of things, but primarily focused on is the conflict that Rashbaum had with representing Charlie after he'd already represented Donna, and that he subsequently represented Donna for almost 11 months. So I think that that's something that's going to be very, very, very on point, because this whole issue, as Judge Everett's decision specified, is that Rashbaum, it was unethical for him to represent Donna in this trial. So it took him many months to figure that out, of course, but they finally got it right. The judge got it right. And what that does, though, is leave the issue of like, well, was it also unethical for Rashbaum to represent Charlie after he had represented Donna for many years while she was in a holding pattern waiting to see whether she was going to be arrested and indicted and charged with the murder of Professor Dan Markell. So I think that that's going to be real interesting and key to see what develops with that. So I'm going to plan on jumping on Friday night to cover that. So it's otherwise going to be, other than that appellate issue, it's going to be probably a quiet number of months on the Markell case that we're trying to get justice for, because the fact that Donna's going to have to get new lawyers and they're going to have to start all over from ground zero, and trying to build up the proper time frame to get up to speed on the case. And also, are they going to try to get her to plead guilty, or is it going to go full-blown jury trial again? So I don't think she's going to want to go for any kind of guilty plea, at least not initially. And the chances are she does it down the road are probably slim to none. And so more to follow on that. But there's going to be sort of a lull in activity, at least court scheduled wise, that occurs in the next 6 months. But I do think that there's still going to be twists and turns on the Adelson cases against the Florida Adelson. So stay tuned. More to follow on that. So with the Sarah Boone case, this is one that is getting more traction than I think the Markell murder of Professor Markell has ever gathered. This one happened in 2020. It happened in the Orlando area, Winter Park, and Sarah Boone actually was started out the evening just having some time with her long-term boyfriend. They've had a lot of violence, both directed at each other over the past number of years that they were together. And as recently as 2018, she was initially arrested for strangulation of her boyfriend George. So he had also assaulted her. So there's a lot of drinking, a lot of domestic violence type of situations between both of them. And it looked like in the 2018 situation that Sarah was the aggressor, that she actually moved to choke George around the neck as they were fighting. So and that was strangulation. So that was initially charged as a felony. And looking at the court records, I didn't see anything how that one panned out. So it looks like that was voluntarily dropped at some point. So she never actually went to trial on anything like that or had a plead on anything like that. But there's other indicators, though, that there was longstanding violence between them. So with that, that evening they were eventually drinking some wine. The stories of if you've been following this case closely, the stories are quite divergent on how much she had to drink. And in any event, they had some wine, 2 wine bottles there. She says they had one at one point, and how much she had versus how much George had, that was never clarified from what I've seen. But in any event, they wanted to then play hide and seek. So what develops is Sarah decides to zip up the suitcase that George went and hid into. The suitcase was a pretty large type of suitcase, and he was a pretty small guy, so he was able to fit inside there. But she admits to zipping up. The rest of it, up to 2 fingers, remained for I guess some kind of access out of there. But he was never able to get access out of there. And so with that, the Sarah's basically teased and mocked him while he was there in the suitcase, begging to get out. And she eventually went upstairs and before doing so, filmed some of this as well. So that's very incriminating as well. Law enforcement was able to get some of that on tape off her cell phone camera. So what happened is she supposedly came down the next morning and then finds him dead in the suitcase. So when she's apprehended by the police and they show up there, she's actually saying that this is a matter that was total complete accident. She didn't really sound too alarmed, the fact that somebody had died in her apartment during the night, and she had her hands on and directly responsible for this. So it looked like he basically was also intoxicated, but he wasn't able to figure out a way to get out of there. And whatever openings there was in the suitcase, apparently she opened up the suitcase and tried to give him CPR and found him dead, and called first her ex-husband, who lived a very short distance away, before the call to the police. So in the initial hour or so that this developed, with the police showing up and whatnot, it doesn't appear that she's too shocked by this. It doesn't appear that she's too traumatized by this. And but then anyway, she's interviewed by the police a couple times. There is a longer interview, a 2-hour one, where they really try to get to the bottom of it. They have looked at the videotape and they see what she was doing. And she made a lot of defenses and excuses, saying this was an accident. I didn't mean to do it. I had no intentions to kill him. But in the end, they eventually charged her with second-degree murder. And so I was looking at second-degree murder statutes, and there's also the offer of a lesser charge of manslaughter that they offered for her on October 7th, actually in a court proceeding. And she turned that down with that October 7th hearing. She could have been pleading guilty to manslaughter, which can include in Florida culpable negligence, which is like a reckless disregard type of element for that. And it seems like that was a really good deal that she should have pursued. And because she actually, despite her being intoxicated or claiming to be, and other times she said she really wasn't that intoxicated, but in the end, assuming she was intoxicated, that voluntary intoxication is not a legal defense to this kind of crime. So basically, if she got drunk and passed out upstairs and forgot to go check on him, that's still culpable negligence, even though could have been likely due to her alcohol inebriation. So with that being said, I think that what I'm seeing so far is that with her having a secondary murder charge on there, that the jury's going to look at the key thing for the second-degree murders. And in Florida, it requires there's some words in what we call elements as attorneys, whether you're not a prosecutor or defense attorney, we call them elements of the crime. So in looking at the elements of the crime for Florida, secondary murder talks about you must commit an act of unlawful killing another, and involves a depraved mind. And the depraved mind is described by case law as a person of ordinary judgment would know this is reasonably certain to kill or do serious bodily injury to another, and is done from ill will, hatred, spite, or an evil intent. And 3, indicates an indifferent to human life. So I think with her intoxication and whatnot, I think the defense counsel is going to try to say that she didn't have any hatred, ill will, spite, or any kind of evil intent. But that's something for the jury to look at. I think the jury would look at this as something that is somewhere in between second-degree murder, and if they may have some sympathy involved and try to knock it down. There could be a few jurors like that think, well, we don't want to go all the way to murder too. She doesn't seem like a killer or whatnot. But part of the thing is also, like I've said on the Adelson murder case, the thing is we've had many jurors that look at situations, and if they don't like the defendant, if they don't like Charlie Adelson, if they don't like Adana Adelson, that's something that does factor into their consciousness of reviewing the facts, whether they know they're doing that or not. But that's what jurors do have a tendency to look at, is how likable is a person. And so we definitely have not necessarily a slam dunk for secondary murder for the prosecution, but I think that they focus on the aspects of the depraved mind, that it's something an ordinary judgment person would know not to do. Don't leave somebody in a suitcase, especially if they're begging to get out. And her making insults and jabs at him, saying this, now you know what it's like, the way you've abused me, those kind of statements she made to him, while she was recording, and she eventually goes upstairs and left him there. So that could meet definitely the third part, which indicates an indifference to human life, leaving him there while he's begging to get out. So I think the thing that the prosecutor needs to make sure they really address well is the ill will, hatred, spite, or evil intent. I think her comments like that, indicating this is payback or words to that effect, will help establish that. So it's very much how this jury's going to slice and dice it. And it's very critical in any kind of criminal setting with a jury to make sure you really hammer down these kind of elements when you're doing jury selection. A lot of prosecutors and defense counsel try to gloss over the elements. They don't really try to focus on that, and they don't explain it to the jury. And what you then wind up is the jury doesn't really understand what the prosecution or defense was driving at, and they come up with what they think is their interpretation, but based on the judge's instructions. So one of the things that's critical as a defense attorney is to actually make sure you look at not only the statutory elements of what the prosecutor has to prove if you're in the prosecutor's seat, but also what do you have for the jury instructions, because the jury instructions can be oftentimes even just important or even more important, because it may provide some kind of defenses and whatnot. So you may think just looking at the elements as a prosecutor, oh, hey, we got these elements met. But in the essence, you actually have some other jury instructions that take away, based on the fact pattern you have for the particular case, they may take it away where you actually don't have a case. So one of the things, for example, is like for assault kind of cases, if you have self-defense and whatnot. So you look at the elements for assault, for example, unlawful touching, causing bodily injury, for example, is a generic sense of assault. But what happens if it was justifiable because of the person acting as self-defense, right? So that's the kind of situation you got to look at the whole picture. What is this, both the statutes that you're charging with, but also is the jury instructions that can really give that a much narrower interpretation and provide defense a big loophole, if you will, to be able to win the case on. So with that, I also looked through the court filings on this case there, just like in Leon County for the Adelson's charged with murder. We do have the defense filed a motion to exclude the battered spouse syndrome defense. That's something that was raised by the current defense counsel, James Owens, that's representing Sarah Boone. And James Owens is a longtime defense attorney, and he wasn't given a lot of time to prepare for this case. I know he asked for an extension, and the judge was tired of this thing being kicked down the road because of multiple defense attorneys. He's now the 8th attorney that's on the case. Most of the time was due to conflicts with Sarah Boone. A lot of that was self-initiated from her, from what we're reading from the record. But in the end, the judge just got pretty much fed up with it and says, we're going to go to trial. We're setting this date, whether you have an attorney or not, we're going with that date. And I can tell you that's sort of a scary proposition when a judge boxes in a lawyer and on a murder case, even though it's not first-degree murder, on a second-degree murder case, when you have a judge saying to a new attorney on the case who has no history with the defendant, no knowledge of this case, he's just coming in cold and fresh, and he's got to build up a defense for this defendant, and having a set targeted date that you can't even tell the judge that's the date that's fine with you. He did say this date is not workable for him, and the judge said you're going to have to try it anyway. We're tired of her delays. So what you should not have a judge do is account for the reasons for the delays previous to the time this current attorney's on the case. What the judge should do is what's reasonable for this attorney given the fact that he just got on this case now. So just getting on this case now, giving somebody only a couple months to try a secondary murder case is really extreme. And so I think this is, one of the big appellate issues that's already been created on the record. So it hasn't even gone to trial. So just sort of like the Adelson case against Charlie, that and Donna having conflicted counsel, that conflicted counsel issue was never raised until a few days ago. And by waiting for that long, all that time was wasted. And in this particular case, if this thing gets reversed on appeal because the defense counsel wasn't adequately prepared and didn't have enough time to fully vet out all the defenses and prepare properly, then we could have an issue like for Charlie and Donna, where we have something where there's an abuse of discretion if it's not addressed properly at the trial court level. So I was surprised the defense attorney didn't push back harder and say that I need more time at the when the judge was insisting upon this, and bring up some of these arguments I'm bringing up now that Your Honor, you cannot be holding me for eating up the clock that these other attorneys had with my client. I need at least a year, 18 months, or something along those lines to properly defend this case. So, in any event, I think that is a troublesome thing. I do think that the offer that the prosecutors gave, where she'd be out less than six years for the manslaughter charge, I think based on the evidence that that's something prosecutors are willing to do. Some people may say, well, it's a little bit overcharging secondary murder with that depraved mind type element, but I think it's still in the realm of reasonableness, and I think that's a lot of times what prosecutors do, they charge on the upper end of and they sort of like get near to crossover line of unreasonableness because it helps them have leverage to be able to negotiate a plea agreement with the defense counsel. So in this case, dropping off from looking at 22 and a half to life, if she's convicted of this charge, to dropping it to where she's actually going to serve with good time under 6 is a really fair deal from the prosecution. And maybe they just want to get this case off their deck. They're tired of dealing with her, and she's just nothing but a pain to deal with. So at least she has a lawyer now, but maybe she's going to fire the lawyer midstream. It's just a headache. So I just think maybe they're looking at it from that standpoint of like, let's just try to bury the hatchet on this thing, get this case closed out, and move on. So in any event, she's not wanting to apparently settle for anything. She wants to go full contested. So that's something that also an attorney, if you haven't been on the case a long time, that can also impede your ability to properly represent your client, because you got to build up the rapport with them, develop some kind of trust and whatnot. And he's been on the case such a short time. Develop that kind of trust to negotiate this kind of thing could be an impediment, because you're just sort of firing away. You're filing all these motions. You're trying to gin up for trial, and you got this gun to your head to be ready to go. So a lot of times you're doing so much prep work on the case, you may not have time to do the hand holding and confidence building with your client. And then when you go in there to say, hey, the state offered us this deal, do you want to take it? The client's not going to trust you. They don't really want to consider that as a reasonable deal. So in any event, that's just another problem you have when the case is rushed too fast with new counsel joining on. The state also on the battered spouse. So we have talking a little bit more about the battered spouse syndrome. That's something that the defense raises as a defense, and battered spouse is normally defense to some act of self-defense in and of itself, where you were basically being beat on, and you then retort and go ahead and take an upper form of violence against a perpetrator that the person is battering you, the spouse that is battering you. So in this particular case, you have this mutual battering going on. So I think that there's a sort of trying to find something to have some kind of jury instructions that can diminish her responsibility, her criminal responsibility. So the state did a motion to exclude the battered spouse syndrome evidence. And the main reason they said is that is only for an accident. Excuse me, it's not for an accident. It's for self-defense, true self-defense. So in this particular case, if you look at the facts, she wasn't actually doing anything to defend herself from any kind of aggressive, assaultive behavior by George. They were just basically playing a game, and she's describing it as an accident. So they're trying to use her own words and saying, look, she's saying it's an accident. So if it's an accident, what does it have to do anything with previous fighting going on between them? So that's, I think the judge is going to have to wait to see how the evidence and how the case is presented by the defense, where they actually decide to bring that out. There could be some pretrial motions ahead of time, because if that's critical to the defense theory, they may want to bring that out in their opening statements, and so they'll ask the judge to make a ruling in advance of that. So So with that, I'm going to go ahead and jump into questions you all have. Some of you guys probably been following this case for a long time. I've been sort of like listening to bits and pieces of it here. And so Lisa Burt, you're saying I can barely stomach hearing about torture, but I look forward to hearing your take on Sarah Boone. What was it about this case that intrigued you, Carl? I think it was really this issue that, that the guy suffered in there and wasn't able to breathe. And, suffocation is one of the worst forms of death. I know different forensic pathologists say, it's if you have to suffocate for whatever means, somebody's choking you around the neck or you can't breathe, it's a very scary, painful way to die. So it's very much sort of like a form of torture. So I agree with that term. And in any event, I think the timing of this and whatnot, it's a case also there in Florida where you get more evidence presented due to their sunshine laws. And also the wild behavior of Sarah Boone, that she's gone through so many attorneys. You don't really see that. She initially, before this last guy, Owens jumped on the case. It was she was pro se, which means you represent yourself. You don't have a lawyer there. So, and I also was intrigued by the fact that the judge is trying to force this case to trial so soon. I think that's something that can come back to bite them. So I'm again concerned about the aspects of abuse of discretion by the judge and how this thing could feed into this whole issue of you push the case to trial so fast that you have all these you have all the key components breaking apart before you can get them all put together and make sure you got a solid case if you're the government. So I just know, I think I've mentioned that before. I had a case where I handed off a case involving it was having to do with molestation of children, grooming, and that kind of stuff by a warrant officer and in the Army. And this case was one that was teed up beautifully because the guy had previously been charged at a different location. And I set up where the victims of that case would come in and testify to bolster the victims of the current case. And what happened was the expert that the defense counsel had used in the previous criminal proceedings, where he actually was acquitted with the help of this expert, they wanted to bring this expert in, and the expert was denied because his schedule didn't totally square up with when the court wanted to proceed with the trial. So they basically said, sorry, if you can't make it here during the time frame we've set for this trial, that the expert, you're not going to make it. You got to pick and choose which is most important to you as the expert. So in the end, that on the Court of Appeals, they held that was an abuse of discretion by the judge. So I see the exact same thing possibly developing here. Basically, looking at the motions, I do think the motions that he has filed are some of the appropriate ones. He's also asked for a psychologist to be part of the defense team and to help with any psychological issues. I think that is a key component. I can tell you anytime I'm looking at a criminal case, I'm looking at who can I have for experts. Experts can really make a big difference in the case. And in this particular case, I think her mental status is a key, and it's something that I think the defense counsel is going to really try to focus on in representing her. So those are some of the reasons why I jumped on that case here with Sarah Boone. Okay, John Barclay, you're asking, can Sarah decide to take the plea deal after the jury's been selected, or did the prosecution take it off the table? A lot of times I would say they give you a short window. They're not going to say, well, let's just keep proceeding a trial and you have time to think about it. And some prosecutors are like, look, we'll give you this sweetheart deal right before the trial starts, but if you don't take it now, we're not going to offer it to you again at all. So, and where they stick that around, it's really just a case-by-case basis, how much the prosecution wants to keep their word on it and not have a reputation of giving deadlines and not sticking to them when they give deals, especially good deals like this. So I think that, as long as they hadn't started calling witnesses, they could maybe get the prosecution to go ahead and reconsider. But that's always real iffy. The prosecution may not agree to let that offer still stand after they've gone through full jury selection or even a partial portion of it. Yeah, Brooklyn Janet, you're saying hearing the man plead is so heartbreaking and disturbing. Yeah, it is, and it's very That's why I think the defense attorney is going to try to go to her mental status is what will be the reason why she wasn't trying to be having a depraved heart, depraved mind kind of thing, and also the fact that she was intoxicated. So, okay, Kathy Barella, you're asking, what are Sarah's chances of being acquitted? I think her chance of being acquitted are virtually none. I don't see her being acquitted at all. And she does have some minimum culpable negligence for his death. He was asking to get out of there. I don't care her state of mind. And no matter what kind of level of alcohol impairment she had, it's not going to excuse her behavior. So I do think she's going to go down at least on a manslaughter conviction, and it possibly could be the second-degree murder if they get the right jury and they present it the right way. Gene Philpott, you're asking, will the judge be able to consult with the family about sentencing if she is found guilty? Well, I wouldn't really call it consulting. What happens is that you have victim impact statements, and the victim impact statements, they can be read to the court through testimony live as a witness there, sitting in the witness box, or it can be via Zoom in Florida, if we've seen in the case with Phil Markell testifying on sentencing for Charlie Adelson's case via Zoom, or it can also be written statements to the court. So any of those kind of things is what the judge can consider when deciding what is appropriate sentence. But if there's a mandatory minimum, keep in mind that would still be in play. The judge can't go below that. There's certain exceptions, like in federal court, if there's substantial assistance provided to help solve other crimes, and in that particular one, then you can get below. If the prosecution does a motion to give somebody credit, then you can get below the mandatory minimums, but that's only if you provide substantial assistance in the eyes of the prosecution. Julie Nielsen, you're asking when are opening statements? Well, they first got to get through the jury selection first. I understand it's going pretty fast here, so I'm not. It could be here in the next. It could be after tomorrow, from what I'm hearing. I'm not too key on exactly what the details were from the jury selection, because we've not had it televised. There's been various reports on it, so yeah, but they are picking the jury now. That is correct. Fly Guy in Blue Sky is saying, ironic, she turned over her phone to the police department. I was too hungover to realize she taped his death while she was drunk. Yeah, when I saw that, I didn't know if she was lying about that or if she really didn't know. So it remains to be seen. Mr. Betsy, you're saying Sarah's her own worst enemy. She brought this on herself and continues to believe she's innocent, but her lies will convict her. Yeah, I don't see her really taking any responsibility whatsoever. I mean, she's as Brooklyn Janet saying, yeah, she's not likable, and that's very problematic. If I'm a defense attorney on a case and I got a non-likable client, it's very much. And even if you got a winnable case, if you got a non-likable client, it really makes it hard for you, because there's that bias against your client just because they act like a jerk so many times. They act like a jerk on video that is going to be played in front of the jury. They act like a jerk in the courtroom, and it's just very, very hard to sometimes do a workaround on that. So, as defense attorneys, we try to make our clients understand that they got to be on their best behavior, and we may go through that with them and make sure they're dressing appropriately, talking appropriately, things of that nature. And but yeah, if you have such a combative personality like she does, yeah, that definitely spells a lot of extra heartache for the defense counsel. Stella, you're saying that don't forget her about her ex-husband will probably testify as to her established history of aggression and violence. Yeah, so I mean, what you have is, if you have mutual violence between the two parties, it's not gonna help her, right? If she's willing to choke the guy out, beat him in the face, give him black eyes, and that kind of thing. I don't I don't think it's really going to help her to bring that up, other than the fact that you're going to see it's a situation that maybe some people on the jury will think, well, she's a female, he's a male, the male should not be responding with any kind of force against her, even if she starts it. So you may have some guys thinking like that. So guys are definitely going to be more sympathetic to her on a jury than any female will be. Rich, you're saying that Sarah walked in the court this morning all smiles and smirks like she's a star in a reality show. And you're saying she's not very smart of a defendant that they're dealing with. Yeah, that's did her defense counsel coach her on how she needs to respond in front of the jury, how she conducts herself? Hopefully, good defense counsel do that kind of stuff. Some defense counsel don't. They just let their client walk in there and have whatever kind of attitude they want to act with. And like I say, it can be really, really something that the jury holds against the defendant. Yeah, Liz Larson, you're saying Owens was forewarned that a new attorney would not be a reason for a 70 continuance. But that's, like I say, that's not something that you want to hold against the newest attorney on a case. If you're a new attorney on the case, you do not want to be constrained to what other people had done and how many months or days or even years this thing has been languishing because the defendant's acting up. You as an attorney have to be adequately prepared. There's a constitutional right to effective assistance of counsel, and the judge puts you on such a tight leash that you don't have the time to be effective, then the judge is basically hijacking the case, and is actually a constitutional violation, and the courts will set it aside on appeal. They'll find there's reversible error. And I can tell you, if I wasn't adequately prepared for a case and a judge wanted to, if I was in a situation with Owens, what I would do is tell the judge, Your Honor, I need absolutely this length of time. There's this many witnesses. I'd cite all the reasons why I need to build that amount of time. And then I would probably say something along the lines that, this is creating an ineffective assistance of counsel. And so if you say those words, like you're basically setting me up for ineffective assistance of counsel, Your Honor, and you do it in a respectful, polite, but very, very firm and forceful way to the judge. And you let the judge know you're not just making this up to create a delay, because a lot of times as a defense counsel, delays help you and your client. The longer the case is delayed out, the better the case is for getting it negotiated down to a lesser charge, lesser sentence. And so you've heard the saying, justice delayed, justice denied. Well, part of that has to do with the fact that prosecutions get less and less interested in the case the longer it drags on. And they need to move it out and clear their docket. So in older cases, they have less interest on, and so that's not something that should be bound, as I said, then by the new attorney, because you're risking reversible error unnecessarily. What's 6 months going to make a difference if you prevent that from coming up on appeal and having to start from scratch? All right, so let's see. Rich, you're saying she's made a mockery of the court and justice system in the state of Florida has allowed it. Enough already. She needs a long prison sentence, justice for George. Yeah, well, we also need to make sure we afford the constitutional protections. We don't want to have people railroaded, even if they act as she's doing in court. And it's something that we have to make sure our safeguards are there. And the judge is going to handle it with a proper discretion and judgment on how to keep her under wraps. But if she wants to act so out of line and whatnot, sometimes defendants can get basically shackled there to the table and whatnot, so you don't stand up and shout at the judge and make a scene and that kind of stuff. So don't think it's going to get to that, but she's got her lawyer there to help keep her somewhat in line. Fly Guy and Blue Sky, it's going to be very difficult to dispute the audio video. She's guilty. Yeah, that really, that's going to be one of the most important pieces of evidence is that video, and you see how you really see how he dies. Not the entire time it took, but just seeing him in there begging to be let out, that's very damning against her. Kathy Prost, you're asking, won't she basically be sinking her own appeal ship by testifying? Well, when somebody does testify as a defendant, it's definitely something that makes it easier for the prosecution. Defense counsel, it's very hard to have your client come across credible. They're looked at with the most cynicism of any witness in the witness box. And your client better have a really good, credible testimony on what exactly happened to make them not guilty. And as we saw from Charlie Adelson, his was not credible. His was so fictitious and bizarre, and probably the least credible defense you'll ever see. So with that, her defense here that she didn't intend to do this murder, that it was all an accident, that some of her demeanor and her attitude is not going to play well for that defense. I'm so tired of saying it's not right to devalue that man's life just because you want to close the case. Well, they're also considering other issues like, hey, what's this worth? If we get a plea out of it, then we don't have to risk it coming back on appeal, getting reversed, that kind of thing. So anyway, I'm sure there's a number of murder cases they have there in Orlando, and the prosecution should have adequate number of personnel to get these things prosecuted the right way. But like I say, this is a matter of like, if we're going to avoid going to trial, then we can offer a reasonable deal, because there is no guarantee you're going to get a second-degree murder conviction if you don't pick the right jury, if you don't have the right kind of persuasive arguments, and depending how she comes across on the witness stand, I think she's going to have to testify in this. And they already had her story on what she said on tape, so I think she's going to try to soften the blows on those kind of things. But the evidence is already there, and how she acted, and how she was cold and indifferent to the suffering of George. So I think it's something where, like I say, she's definitely not going to be acquitted. She's going to be convicted of either manslaughter or second-degree murder. Yeah, Leap Day Boy, you're saying Sarah's her own worst enemy. Yeah, that's really like the Adelsons. They just kept talking and talking, Charlie and Donna, and their own words really helped convict Charlie, and they should help convict Donna as well. Miriam, you're asking if Sarah had been not able to find someone pro bono and forced to defend herself against her will, do you think her appeal would have been a landmark case? No, I mean, if she's pro bono and she's saying she wants an attorney, and she's otherwise fighting with different attorneys and not able to have a good working relationship with them, you can't, as a defendant, just continually be fighting with your defense counsel and trying to get them fired and all that kind of stuff. And I guess somebody's indicating 4 the counsel were removed for conflicts. So if she's on the 9th one and 4 were removed for conflicts, she's been having conflicts with personal conflicts and personality conflicts with the other 4, I guess there would be. So that is something that the judge is sort of like figuring maybe she's just trying to buffalo the whole system, doesn't want to go to trial, and is doing whatever she can to get her attorneys fired. So the judge is, rightfully so, really just tired of her trying to jerk the justice system around like that. So, but like I say earlier, you still need to give the current defense counsel adequate time to do his job. Yeah, sort of reminds you of I see someone's comment here about Katie McBanois, yeah, her deal was the worst job you could ever imagine. Katie McBanois, but here, this one, it's not anywhere near as bad. But yeah, it's definitely something that's not very smart. I think it's gonna come back to bite her. Okay, Mr. Crazy Man, you're saying Attorney Owens knew what he's getting into. Judge made it clear in his order there would be no continuance. He has found plenty of time to be on many news platforms. He's rude and disrespectful to the judge. All right, I would just say that, yeah, I did see that he was told he's not going to have a continuance gathered. Granted, if he's on this case, but still, that you're setting yourself up for abuse of discretion by the judge. So I just think that's too harsh of a ruling by the court, and we'll see what happens here. Rosemary Romero, you're asking if George Torres voluntarily put himself in the suitcase and Sarah Boone and George were drunk and there was no video. Would Sarah Boone still have been charged? That's something I think that they maybe not they probably wouldn't have charged her with secondary murder. Not sure of that per se, but it very well could have been. I mean, the videotapes of what you have for George, and then how she conducted herself in the interview and whatnot. She's just not a likable person. Her story flip flops a lot on what was going on. She generally maintains it was an accident, but you know, some of her other mean behavior before George is just not very sympathetic. And this is, you know, I think the prosecution should focus on the outright cruelty that she exhibited towards George as he's basically dying there in that suitcase. Patty P, you're saying, won't Sarah have to be voir dire before the judge will allow the defense of battered spouse syndrome? I think what's going to happen is they're going to have to do this outside the presence of the jury, and they're going to have to present a theory as to why. And maybe they'll have to have some kind of interim testimony off the outside the presence of the jury. So a motion in limine describing why is this important to present this defense? How is this properly raised and able to be used to instruct the jury under the current Florida law? So it is possible they could have to present some kind of testimony to persuade the judge to allow this kind of evidence in. Let's see. Yeah, another Jody, you're saying that was not a smart move for her not to take that plea agreement. I agree. That was a very, very fair, more than fair deal from the prosecution. And she turned it down, and yeah, that could come back to bite her big time. It's been 4 years and 7 attorneys for the current one. She's been doing everything she can to delay, says we're Schneffer. So I would say that, you know, you still got to give the current attorney the time to properly defend her. So if he's okay with it, and he says that it's not a problem for him to be ready already this soon. I've never seen a secondary murder case happen this fast. So it's like rocket speed, and it could create some serious problems on appeal. Whitebird, you're saying, do you think this battered spouse defense will go? Apology if it's already been answered. I think they're going to, you know, that's one of those deals where if you allow the defense in, then it's an issue where you can prevent that from being an appellate issue if it's a close call. If it's not a close call, then do you want to just prevent the defense from just basically smearing the character of George? So I think that there's a chance this could be denied by the court, that the battered spouse will not come in because it really doesn't fit this theory of being an accident. But if they're going to try to frame it as sort of like an overall general mental status where she's has this battered depressed state of mind and she doesn't know how to respond properly to different circumstances, then perhaps that's something that the judge would allow in. But I think this judge is already really tired of dealing with her, so that could be a factor as well. White Devil 7, you're saying that video is instant conviction. I feel sorry for the jury. You can't unsee things. Yeah, that's it is definitely something that is very helpful for the prosecution. So her defense counsel are cringing at that video. I guarantee you that. Watercolor Mama, is it proper for the defense attorney in this situation to plead with the judge and mention the possibility of future appellate issues because he has so little time? Is that improper towards the judge? No, it's not improper if you do it in a respectful way. I recall Rashbaum even doing that, telling the judge that when he was trying to keep out certain evidence, and in the end he wound up losing, and they had Wendy Adelson come back, drive back, and testify again a second time in her brother's trial. So no, you can do that. You don't want to keep doing it every time you raise a motion that the judge doesn't agree with you. But if it's really, you really think it's a appellate issue that could be resulting in a reversible error, then you can strenuously object that, and like I say, in a respectful manner, but strong manner, let the judge know that is a serious concern of yours. All right, Katie Girl and Deb M. I see you're asking about, does Charlie have a chance of winning an appeal and getting a new trial? I would say that it all depends on what's in the brief and how it's written, and how much they're able to tie this in with the conflict that Rashbaum had, how well that's presented. I think that's his only chance of winning an appeal. And I mean, the evidence is slam dunk win against Charlie. It was an open and shut case, but when you have conflicted counsel, that's a constitutional issue, and so there is a chance. I don't know how strong it is. I think it's probably a more likely than not type situation where Charlie's case could be reversed on appeal. And with that being the case, and where's the prosecution be stuck at? That decision come down in maybe a year and a half, let's say, and then is Donna even going to be to trial then? And then you're going to go one at a time before you go with the second one. I mean, this whole one at a time strategy is just, I think, going to really come back where they bite them. In fact, I just saw John alerted me to another Florida attorney that used to work down there in the state attorney's office, Jeremy Mutz, and he was actually saying something I've been saying along, is it's actually more advantageous if you would have charged all these accused murderers all at the same time. So that's something I've been advocating for a long time, because that's how you really get these people to rush and try to plea bargain, and you wouldn't have had this conflicted issue with Rashbaum. I don't think Rashbaum would even have dreamed about trying to represent Charlie and Don in the same trial, and so it would have looked so corny, and I don't think he would even attempt to do something like that. I think the judge would have maybe shot that down, but maybe not. Things are so crazy down there in Tallahassee. But in any event, I hope I'm wrong. I'm hoping wrong that he doesn't have a winnable case on appeal. But if you look at the big justice picture, do you really want people that are conflicted like Rashbaum defending people out there that are co-defendants on a murder case? It just really rubs you the wrong way from a constitutional due process standpoint. Lord Pender, you're saying conspiracy theory. Donna and Rashbaum purposely did this so Charlie could have more legitimate grounds for an affirmative appeal. Yes or no? I don't think that's the case. I think that Rashbaum was not aware of this. I think that for him to actually commit an ethical violation, that as a judge ruled an ethical violation to represent Donna and Charlie, I just think that I think he's really clueless on what this is about. I just don't. There's nothing I see from how he represents Charlie and what he's done with Donna. I just don't see him as like a a sophisticated, knowledgeable person on the finer details of the conflict issue, constitutional conflict issue on these two defendants that he represented. All right, let's see. Next we have here. Yeah, I'm not gonna talk about her any mental diagnoses for Sarah, because that's not something you do as a prosecutor. So I'm taking this more from the prosecution standpoint, even though I'm a current defense counsel. Been on both sides, prosecution defense, for many years over my what is it now, 34 years of practicing law. All right, Cheryl, in case you missed it, her plea deal was they offered her manslaughter, and she was going to do basically 15-year sentence, which would mean she'd get out in less than 6 years there in Florida with good time. Brooklyn Janet, you're saying because it's a heartbreaking case, I believe suitcase should be manufactured now with a person either able to punch an air hole or unzip the suitcase from the inside. Does that sound crazy? Yeah, I mean, it does sound like something like, what are you going to do? Have another federal law that covers that kind of thing? We don't even have, for autos, you hear all the children and pets dying in heated cars. People leave them in the cars when it's sweltering heat in the summertime, and within a few hours they're dead. And we do have some cars that have the automatic solar powered fan and air conditioning system to keep the car cool to prevent that from happening. But that's not mandated in all cars either. So there's a lot more people that die from heat stroke in cars than they do from dying in suitcases. So I'm not sure that would ever pass. All right, jumping ahead here, a little bit behind. Yeah, Kevin Hornbuckle, you're saying that Sarah Boone's mental status can be objectively described to the jury by forensic psychologists testifying for the state. Yeah, but they also have one for the defense. So if the defense is going to be calling one, then the state can have the opportunity to interview her as well. So it could be sort of a battle of the experts here on what's going on in her mind. Kevin, you're asking about a case in Oregon. I don't do civil law in the state that far away, but glad you got a solid case to go forward on. Letterman's girl, you're saying depraved intention. I would say exactly what was on the recording of her. Am I wrong? No, that's something that you could certainly come to the conclusion on. How much she was serious in that and how much she was actually outright mean and evil and nasty towards them, we have to see what the jury's going to come back, because different people come up with different conclusions. And I think a lot of people do think it's outright evil, but if you get somebody on the jury who doesn't believe it, and you don't present it in a strong way as a prosecutor, don't kick off people that are not aligned to your views of this kind of evidence, then she could wind up with something less. Virginia Lane, you're saying it doesn't matter that the judge had put in his previous ruling that he explicitly would not extend even for a new attorney. Yeah, that's what I'm saying. A judge should not be binding new attorneys to his trial schedule and not give the attorney adequate time to defend his client. You're saying that I feel like that was Owen's warning for what he was getting into. Well, it's still the substance of the fact that this is a criminal law issue. It's a constitutional issue of having effective assistance of counsel. And if you give a counsel only a couple months to get ready on a second-degree murder charge, that's like really shocking and unheard of in the criminal defense arena. The states I'm practicing, I'm licensed in 4 states. I'm not practicing all of them right now, but I can tell you that it goes at abuse of discretion of the trial judge if you ramrod this case through and try to stick by your schedule rather than is this attorney adequately prepared to do the job he's called to do, then you're risking reversing it on appeal. Rosemary Romero, you're asking how can the judge allow the defense to use battered response system if she wasn't battered? Yeah, that's one that I think I've sort of already covered that, but there is some law that talks about if it's not an accident, then it shouldn't be allowed in. So, excuse me, if it is an accident, the other way around. If it is an accident, then what's that really got to do with anything? So I think it's all going to wind up how the evidence and the arguments shape out, and how much the judge wants to be strictly adhering to jury instructions, or is he going to be giving something that's making it a little bit easier for the defense to try to come up with something less than second-degree murder. Okay, jumping ahead here, about a half hour behind, sorry. Okay, I'm hearing a couple reports. Mary Ratcliffe, you're saying they're selecting 6 jurors and 4 alternates. Okay, I've not seen that as of late, so somebody else is saying that as well. Chrissy Ellum. So they're going to need more than that, though. They need 12. So where are we on getting to 12? Plus, you need 12 plus some alternates. Just like in the Charlie Adelson trial, you need 12 plus several alternates in case you have some drop off. Yeah, I'd heard that. Jessica, you're saying George only weighed 103 pounds at the time of his death. So yeah, he was able to fit in that suitcase. I guess I have it completely zipped up. So she was definitely much bigger than him, from the looks of it. Lisa Burton, you're saying she's acting so arrogant, acts like the court owes her something. Yeah, that's going to help her get a second-degree murder conviction. Her attitude, her flippant attitude, and acting like she owns the place. Mr. Bessie, I think she will take the stand because people like that, they think people are going to automatically gravitate and believe anything they say. And sort of like Charlie Adelson. Charlie Gary, you're asking, do prospective jurors lie about their knowledge of the case? And I think they do generally. And I think a lot of them Google it on breaks and stuff like that. Once they find out the names of the defendant, so they'll do some Googling. So they're not going to admit to that. So unless somebody reports them as committing juror misconduct, the court won't find out about it. Letterman's girl, you're asking, is the depraved mind she had in the video easily enough for second-degree murder, especially if being intoxicated is not an excuse? Yeah, it's technically not a legal excuse, but jurors can look at it and sort of formulate their own opinions. They're like, well, did she really intend that night to kill him? How's it go from him having fun to all of a sudden she had a depraved heart just because she had some alcohol? But is it possible? Absolutely. Can they look at the way she was callous and indifferent, reckless, and disregarding of his pleas? So that could very well be the case, but it's not necessarily a slam dunk win like it is for the Adelsons. Okay. All right, so let's see. Kelsian, you're saying I don't believe this the appellate court will see it that way. I don't know which appellate court you're talking about. Are you talking about this case or the Adelson case? I've been talking about both tonight. Charlie Gary asking the same kind of thing earlier as I just answered. Prospective jurors can lie about their knowledge of the case to secure their place on the panel. Yeah, absolutely, especially if they see a lot of TV cameras and stuff like that. And so that kind of stuff can definitely does happen. There's no doubt. Okay, Lisa Mon, you're saying what can family members do in murder cases that are so obviously guilty? Well, the family of the accused, they pretty much always will side with the accused no matter what happens, no matter how strong the evidence is. So that's what they do. They're going to believe in their family member over any evidence, no matter how strong and convincing it is. They just are not going to want to open that door in their minds. So um, don't quite understand that, but that's the way mostly what I've seen on cases I've worked. Jessica Eden, you're saying you had some sympathy for her going into it, but she's been so abusive to 8 attorneys. Yeah, I mean she's not cutting any favors with herself, and I think some of the jurors will probably Google that and find that out as well, and have even less sympathy and concern for her, and they'll maybe help use that to convict her of second-degree murder, even though technically they're not supposed to. That's the kind of stuff how it really works in the real world. Lisa, H4, you're asking if I'll be covering the Delphi case at all. Your insights always outstanding. I think that's the Indiana one. If there's some kind of issue with a cult as well, from what I heard. I know I've talked to John briefly about that, but I do not know enough about it to cover it just yet. But I think I saw that was also starting as well. So not sure yet, but I'll consider it. I'll talk to John and I'll reconsider. How about that? All right. Nick is asking, do I think the judge won't delay because he thinks the defense counsel will quit if they have to deal with Sarah for another year? So just press on with a short timeline. That's a good theory, and so that could be in essence a factor, but in reality, the way it should work from a constitutional perspective, effective assistance counsel is not just hurry up and get this thing in a trial as fast as reasonably possible within such a short time where the defense counsel can't adequately prepare. And so it all depends how good a job he does. If he does a good job and he's able to present an adequate defense for it during that time frame, then I would say it's not going to be an issue. But it's still scary to see that as a criminal law practitioner that someone is given that little time to prepare. Jane Kreisman, you're saying, or Christmas, sorry if I'm mispronouncing. You're saying her neighbor told law enforcement that Sarah told him she was teaching him a lesson. Won't that sink her defense? Yeah, those kind of statements definitely indicate that she had more of that evil intent. But could it also be like she's trying to teach him a lesson and not actually kill him, but just let him stay there and basically have him as a captive in that suitcase? So that's going to be the fact issue that the jury's going to have to ultimately come up with. The defense is going to say that she just fell asleep upstairs. She didn't mean to kill him. They were just playing around. They're horse playing, and he went in there himself. It wasn't her. It was his idea, never hers. So why would she have formulated that intent in such a short window? But in any event, Deep Day Boys, you're asking if you act as your own attorney, can you later claim ineffective assistance of counsel? No, you cannot. Okay, Martha Duncan, you're saying Ms. Boone has changed her story a few times. Perjury is a possibility. I don't think they're going to charge perjury when she's going from one story to the next and whatnot. I don't think it's calculated enough that they would charge that. And the fact they haven't charged it now and it's ready to start a trial, I think that obviously they're. I don't think they plan on charging it any time now or later. But that's just from my experience. How serious the perjury has to be before they charge. Hanno, you're asking how do I expect Sarah Boone will perform on her cross-examination? I think she's going to be absolutely self-destructive on cross-examination. I think she's going to be very, very much a person that's going to shoot themselves in the foot and guarantee a conviction. And is this going to come down to where the second degree or the some type of manslaughter, involuntary or voluntarily? So I think that in the end, if she comes across as like she has in some of these other proceedings and just basically is such a unlikable, hateful kind of person in the actual trial, then it's that much easier to get a conviction for second degree murder. Bitfire, you're saying it's disturbing that Sarah's never shed a tear from day one at home to present, not for George, not for arrest, not for son, no tears. Yeah, that's something that's very striking and troubling, isn't it? BBE's asking, do I think Wendy will ever be charged? I think she will be. I just think that, I'm just very, very frustrated right now what's going on down there in Tallahassee, and I'll just leave it at that for tonight. Kiomani, same kind of thing. Why does state always go for the harshest sentence yet bulk of Wendy? Yeah, I mean, they haven't even got her charged, so. Okay, here's a good question. The two is asking, what are the pros and cons of having 6 or 12 jurors? Are 6 in her best interest? No, 6 are not in her best interest. I can tell you that you always want to have the most number of jurors on the case if you're a defense counsel, because it's that much harder. It's easier to get 6 people to agree to convict than it is 12, because you always can have a chance of an oddball juror that doesn't agree with the others, that wants to dig in their heels and say, we're not going to convict. There's no way the state's proven their case. And so definitely having 12 makes it tougher for the prosecution and easier for the defense. Okay, let's see here. Jumping ahead here at 8:46. Kathy, concerning domestic violence and one spouse being hit and other defends themselves, leaving marks on the abuser. Why is the abused spouse also arrested? Yeah, that's something that pretty much universal across the United States. They have an arrest policy. If one person touched the other spouse, automatically they both go to jail, even if it was self-defense. I think that's a very stupid policy. What they're trying to do is, in essence, take away discretion from the police officers and leave it up to the prosecution to decide what should happen. I know I've represented plenty of females accused of domestic assault that they were the exact same thing happened, where they were being had a history of being abused, and then the prosecution, they have a cop that shows up and it's he said, she said, and they'll take the word of the guy over her. and then what happens is the prosecution gets it, and I basically tell them, what exactly was going on. If I have a prosecutor doesn't agree to dismiss a charge, then I go to trial and then get acquittal that way. So in any event, it's just one of those policies. They don't want, if somebody lays down on somebody else, that's considered an assault as well, even though it's self-defense. I know it's not meeting the elements of proper assault, because you got to factor in the defense of self-defense. But they take that discretion away from the cops, because they just want folks not to be laying a hand on anyone, and you're going to jail. So if the cops show up and both of you say you hit each other, the cops aren't going to figure out who's telling the truth. They're going to arrest you both and charge you both with assault. Judy Sullivan, you're saying, another person saying people won't be able to unsee the video. Yeah, the video is definitely very damning for her. John is overseas, so I don't have John with me here tonight. All right, so jumping ahead here, looking for questions with red. Morium is asking, I think the defense attorney's looking for that purple-haired lady from the Katie Sigfredo trial that they'll get a hung jury for Sarah. And, that's what you're looking for, is sort of an outlier. I'm not going to give all the tips and strategies as a defense attorney what I look for, because I don't want to help anything on the Markell case. But I do have some definitely people as defense counsel, certain backgrounds I definitely moved to kick off the jury. I'm just not going to cover those right now. Okay, apparently in Florida, you're saying Florida second degree only gets 6. I think that's a bad move. I don't agree with that. Second degree murder, I mean, you can do life. You can get a life with only 6 jurors convicting you. That's a shocker. I can tell you, in military court martials, you never have unanimous votes to convict, and that's something I think is troublesome as well. So yeah, I've had like misdemeanor cases with 6 jurors, and we get through them a lot quicker. And I have not had a problem with those. When you got something like somebody's life's on the line, you only got 6. I think that's not a good thing. I think that's a poor system for a due process, because if you can take away life, I really think it needs to be 12. Linda Munn is asking, what strategy do I use to cope with all these murders? Well, I don't try to cover too many of them, okay, because they can get really disturbing to watch. Like the Kohlberger case, like people asking if I want to cover that one, and that is such a gruesome one. It's so sick and disgusting, and it's just, as soon as I saw that he got arrested, I quit following that case, and I've only been listening to a few things here and there. So because some of you are asking me to cover it, I will consider it, but it's really such a disturbing one. It's hard for me to have much of an interest in pursuing that case. I do think they got the right guy from what I've seen, but there's some noise out there. I'm just not listening to it right now. Yeah, if the Delphi case doesn't have murders, yeah, that'd be hard to cover it. That's the nice thing about Florida, at least maybe not during the jury selection, but once the evidence starts and the arguments, the opening statement starts, you get to see all that. Yeah, serendipity smiles. It was a highly toxic and dysfunctional relationship. I totally agree with that. Jake Kid, you're asking, can there be any viable defense with that video that she took of herself? Well, they're just going to try to make it out where she's sympathetic. She has mental issues. You can't hold it against her, but with her personality being so abrasive and abusive and that kind of stuff. But I think as a defense attorney, you're going to try to get the best expert you can to try to minimize her state of mind during the time this happened and try to take some of that culpability away. I think that's probably going to be the best thing. But then again, with the way she comes across, and then if she testifies, it's going to undo any good that expert does probably. Yeah, I don't know whether she ever put her son in a suitcase. I haven't heard that before. So, how is a blackout looked at as a defense in general? Well, it's not a defense, so it's not technical legal defense. But what you can have jurors do is they'll look at it from a common sense standpoint. Is it possible she was just playing games and wanted to go upstairs and then she passed out, blacked out? But her story's changed so much on the alcohol and stuff like that. I don't think it's going to be that good. But um, I have a case where I'm thinking of right now in Italy where someone had that as a defense that they blacked out and they didn't know what's going on. There's some kind of assaultive behavior and disorderly conduct involved. And so yeah, it's not a defense, but you got to factor it in and figure out how it can help you try to sort through the evidence. But if your client doesn't remember anything about what happened, it's makes it a real challenge from that perspective. All right, let's see. I'm going to take a couple more questions, and we'll sign off here. Kathy Burrell is asking, I don't understand why Wendy hasn't helped her mom with a lawyer. Well, Wendy won't even talk to her mom. And think about it, if Wendy was innocent, why would she help her mom? If her mom's innocent, why would she help her? So if all these Adelsons are innocent, why isn't Wendy talking to them? Yeah, it's just really bizarre. So if she could find a lawyer for her. No, she's not going to help. Charlie's going to have to do that. It's not going to be Wendy. She's trying to duck and run as fast as she can from everything she can. And well, she'll never talk to her mom or her brother Charlie again. Fletcher Boy, you're asking a YouTuber was in court today said that several in the jury pool said they never heard of Sarah Boone. Does this make a jury sitting easier? Absolutely. If they don't know anything about the case, that's the best. Assuming they're being truthful now. If they're not being truthful, then maybe they already have their mind made up. So if they have heard about the case, generally it does help the prosecution, I would say. And if they're not being truthful about it, then they probably want to stay on the case. And usually, though, I would say those tend to be prosecution-minded people. Not always, but more than likely, that would be my instincts. Keel Manny's asking, I really believe this was premeditated. Well, they didn't charge it as premeditated. The state didn't, so they don't think it's premeditated. Although premeditation can occur like in a split second or seconds. So in this particular case, I think the fact that she so many times said it was an accident, I think that they decided not to charge her with murder in the second, and like I say, they're willing to cut her deal that she turned down. So that's such a strange outcome. But here we have the trial coming out, and it's not going to take that many days to get her convicted. Terry's asking, have I ever dealt with a not guilty by reason of insanity type of prosecution? I've had, not as a prosecutor, but as a defense counsel, I had a case in Germany where somebody took a Kevlar helmet and did a roundhouse smashing over the head of another soldier that didn't have a Kevlar helmet on. Kevlar helmets are really heavy. I don't know how many pounds, but let's just say they're maybe like 10, 12 pounds, something like that. And it's caused some serious fracturing of the skull, some brain injury and stuff like that. That was quite traumatic. And that person was an MP in a room with MPs. And that's sort of what I've heard is like the definition of insanity. If somebody would commit a crime right in front of a room full of law enforcement. So that one was the only one I had experience with. There's a lot of issues where I've had sanity boards requested because of issues with clients blacking out or not having memory of things that happened when they're charged with a crime. So those are the things you have to do as a defense counsel. So I was glad to see that was being done by defense counsel Owens, to have a forensic person there, psychiatrist, to examine her and aid in the defense in that way. Yeah, Vertice. Okay, thanks for again citing this in Florida. It's second-degree murder. It's only 6 jurors, so that's very, very strange. And it's not. It's very unusual. I'll tell you that. Fletcher Boy's asking, our UCMJ, that stands for Uniform Code of Military Justice Rules in Court, drastically different than civilian courts. The only thing different I would say we have in civilian courts is how the jury's selected. It's handpicked by the commander, almost always a general, like a 2-star general or higher, and they only have to have 2/3 vote to convict. They don't need unanimous, and you'll never see 12 jurors on the panel unless it's a death penalty case. So it's in forms of the elements of the crime, unless you're talking about military specific offenses like disrespect to a superior commissioned officer, those kind of things you don't see like in the civilian courts. Those kind of actual military specific crimes, but everything else, if you're talking about assault and battery or rape or murder, all those kind of elements are all the same. You have the same kind of jury instructions, the same kind of elements of the crime, and they're spread across all services. So if you've done court martials, you can easily transfer and translate that experience into any kind of criminal court in America. Okay, just want to follow up, Mary Metal. You're asking why would she be charged for not getting him out? Didn't he put himself in that suitcase? Well, he did initially, but she admitted she helps zip it up. So with that being the case, I mean, she helped take the affirmative act to help zip it up and leave such little room for oxygen that he did in fact die from lack of oxygen. Let's see here. One last one here. Elizabeth, I want to go this one. Elizabeth, you're asking how likely is the jury to sympathize with a battered partner defense in the context of Boone case, where we clearly see the video of her taunting him. Yeah, I mean, she does look like the aggressor in this situation. And like I say, to 2018, I found the court records where she was arrested for trying to choke him, George, when they're still dating at that time as well. So, and she's apparently has weight and size advantage over him. So definitely it's something that will factor in the jury's mind, that, you know, who's really the aggressor here? Is it mutual, or is she actually more the aggressor than him? So trying to introduce this evidence, you better know where the background really lies and who is a more aggressor of the two. Because if she's more the aggressor one of these two, and she's the one putting more the injuries on him than vice versa, then that's something that could really backfire on the defense. All right, so with that, I'm going to go ahead and sign off, folks. So thanks for joining and supporting justice for this case as well. I generally take it from the standpoint of what the prosecution needs to do, because in this particular case, it looks like definitely she's guilty of something, at least the manslaughter charge there for the elements of the crime there in Florida. So with that, I think what I plan to do is at least cover the trial at night. I don't think I'm going to cover any of the actual case from start to finish, but in any event, I'll have a night recap once we start having the testimony at trial and the arguments and whatnot. So with that, I'm going to go ahead and sign off. You guys have a great night, and be safe.